Hello, scholars. This is Mr. Myers on 3.1, the American Court System. Make sure you take good structured notes over the objectives. Today we're going to be talking about the differences between different types of law, different types of jurisdictions, the concept of standing, the concept of the dual court system, talk about trial courts, appellate courts, the Supreme Court, and then you basically need to know how a case moves through the system. All right, let's go ahead and begin. So let's start with some basics. First of all, there are a couple different ways to think about categorizing law. The first way we're going to talk about is the difference between common law and statutory law. Statutory law refers to laws that were passed in a legislature, how you traditionally think of laws being passed, right? Whether that's a state legislature or the U.S. Congress. The other kind of law is common law, and common law is the established law based on a series of court rulings. And an important concept to understand related to common law is the idea of a precedent. So a court will issue a ruling, and that ruling will guide future courts in how they rule on decisions related to that. And over time, it becomes kind of the settled law of the land. So it's a little bit different than a law passed in a legislative environment. We also have a difference between civil law and criminal law. Civil law refers to two parties that are in conflict, one possibly suing the other or possibly both suing each other, and that could be related to a divorce. That could be related to, a neighbor's tree fell on your car and he refused to pay for it. But two parties that are trying to settle some kind of dispute, usually not related to a crime. Criminal law is when a crime has been committed and one of the two parties is the state. If someone were to break into your house, it's really not up to you whether or not to prosecute, it's up to the state. So the state would actually be the prosecutor, and then the person who committed the crime would be the defendant. Now let's talk about jurisdiction. Jurisdiction refers to the ability to hear a case. There's two kinds, original jurisdiction and appellate. Original jurisdiction refers to a case being heard for the first time. It's almost always in a trial court, right? If someone doesn't like the results of that decision, then it could be appealed to an appellate court. So appellate courts have appellate jurisdiction, the ability to hear a case for a second time. A simple way to remember that is the word appellate looks like the word appeal. So in order to bring about a case, there are three things that someone would need. The requirements for a case first start with standing. Standing refers to the fact that you have some kind of stake or role in a case. You have to prove that you're involved in some way. So you can't sue someone because you didn't like what they did to someone else, right? You have to be personally involved. There also has to be a case. There has to be some kind of harm done. You can't ask the court to offer opinions on hypothetical situations. There has to be some kind of, actual action that's been taken where harm has been produced. And if one of the parties is the government, right, the state or the federal government, the state has to have taken some kind of action, again, that was involved in harming you in some kind of way. Now, the last thing we need to know from this slide is the fact that America has a dual court system. So if you remember the concept of federalism, where the federal government has some powers and the state government has some powers, and then there's some powers that are shared, this is similar to that in that there is a federal court system and a state court system. And whether or not your trial ends up in a state or a federal system depends on whether or not you've committed or violated a potential state or federal crime. So let's start with the most basic courts at the state level, the trial courts. So these are referred to as circuit courts. They have original jurisdiction over cases of state and local laws, so that means that they'll be hearing cases for the first time if it involves a state or local law. Cases will be argued before a jury or a judge, depending. Sometimes the defendants have a say in that, who will ultimately decide the facts of a case and determine guilt or innocence or blame in a civil case. And these courts are split into different types of courts, and that's to help specialize. There are criminal courts at the state level. There's municipal courts, which are the most common, that would deal with like traffic ordinance violations, speeding tickets and things along those lines. There's family court, a small claims court where people can sue each other for amounts under, up to a couple $1,000s. Probate court, which deals with wills and estates when people die. So it's kind of split up to specialize. And there are 45 different circuits. About 350 judges handle about 500,000 cases annually. but it's important to keep in mind that the vast majority of those cases are, again, tickets, traffic ordinance violations, things along those lines. Okay, so the federal equivalent of those state circuit courts would be the district courts. These are the lowest trial courts where cases would be heard for the first time, dealing with issues of federal law or people from different states. Again, cases would be argued before a jury or a judge, and there's about 94 districts, 2,800 judges that handle about 400,000 cases annually. Okay, so if one of the parties doesn't like the outcome of the case or they feel like their rights were violated in some way, they could appeal. So at the state level, the next place a case would go after those circuit courts would be the intermediate appeals courts, or just simply the Missouri Courts of Appeal. They have appellate jurisdiction over state trial court decisions, so it would be the first place that a state decision would be appealed to. Cases are argued before a panel of judges who will decide whether or not there was some kind of due process violation at the first trial. And in Missouri, there are 3 of these courts that have about 32 judges that hear about 2,700 cases annually. The federal equivalent is the U.S. Courts of Appeal. They have appellate jurisdiction over federal trial court decisions. Again, cases will be argued before a panel of judges who are going to be looking at whether or not there was some kind of due process violation, due process referring to the law not being followed or applied arbitrarily or differently from one party to another, and deal with issues of constitutionality of federal law. There are 13 of these courts, one of them downtown St. Louis, the Thomas F. Eagleton Courthouse. They have about 700 judges who hear about 55,000 cases annually. The last court of appeal at the state level is the Missouri Supreme Court. They have an appellate jurisdiction over all state court of appeals decisions and all cases involving constitutionality of state law. So anything related to the Missouri Constitution would be decided here. The cases, again, are argued before a panel of judges, and one court, 7 judges hear about 80 cases. And the last court of appeal at the federal level is, of course, the U.S. Supreme Court. They have appellate jurisdiction over all federal courts of appeal and all state Supreme Court decisions. So it is possible actually to appeal a decision from the Missouri State Supreme Court to the U.S. Supreme Court, again, depending on the circumstances. These judges decide the proper application and constitutionality of all laws, at the federal and state level. And there are 1 court, 9 justices, and about 100 cases annually. Here's a simple little flow chart to help you remember the names of the various courts and how they move through the system. You might want to copy this down into your notes. Please bring any questions to class and have a great day.